Hello and welcome to our Top 10 Title Question Series, the final day.
Our final question for today is, what are the standard exceptions and how do we get rid of them? As you know, when we write title, we examine the public records to determine what exceptions are appropriate on a policy. But things exist outside the public record that can also give rise to exceptions on a policy. The standard exceptions deal with those items that exist outside of the public records that we have the ability to check.
The first standard exception I'll read off here is number 1 is defects, liens, encumbrances, adverse claims, or other matters, if any, created first appearing in the public record or attaching subsequent to the effective date hereof, but prior to the date of the proposed insured acquires for value of record the estate or interest or mortgage thereon covered by the commitment. A lot of words there. This one is really what they call the gap exception. It's really what they're talking about is anything that a owner or of a property may do to a property that doesn't show up in the public records, that might be of that gap period in the recording of the county. So the way we get rid of this is by owner's affidavit. At a closing, the owner will sign an affidavit saying that they have done nothing to the property that would cause anything for this exception. One of the things they got to understand in title insurance is we do not insure against things that an owner does to a property. So we don't insure against your own actions, and that's what the owner's affidavit that's why that takes this exception off the policy.
Exception number 2 is any encroachment, encumbrance, violation, variation, or adverse circumstance affecting the title that would be disclosed by an accurate survey and complete survey of the land and property. While we examine the records to these properties, we don't actually see them. So the location of the physical structures on the property are something that we have no way to check beyond having a surveyor go out and draw a survey of the property and tell us what's there. The submission and review of a survey to the property enables us to delete the general exception to do with survey matters, but may give rise to certain special exceptions if the survey shows that there's a problem.
The third exception is rights or claims of parties in possession not shown in any public records. This is pretty standard for somebody to own a property and have a lease or a tenant in the property where there's nothing recorded on the property. That tenant does have rights to the property, and we're telling you in a standard exception that we're not covering any claim that comes up because of this right that this tenant has. So the way to remove this off a policy is, again, in the owner's affidavit. You will be asked in there if there's any tenants or any leases or anything we don't know about, and that's once you say no to that, that'll be removed off the exceptions. But if there is, then we may ask for a subordination of that lease as part of the process.
And to continue with what Lance was saying, there's also a question as to adverse possession in the event of a boundary dispute. Many times adjoining property owners get into disputes over where the actual boundary of the property is located. And the survey that we talked about earlier answers some of those questions, but the supplement of the owner's affidavit acknowledging that there are no boundary disputes enables us to limit claims of adverse possession that come as a result of boundary disputes. The next standard exception is rights of easements or claims of easements that are not shown by the public records. There are easements that exist and rights of way that exist over property that don't get recorded. Some governmental entities choose not to record their documents if they feel that their easement is obvious and notorious. Sometimes there are open drains or water courses that cross the property that are not evidenced by easements in the record. The review of a survey and the examination of an affidavit given by the property owner enable us to eliminate that general exception.
And the final one here is any lien or rights of lien for services, labor, material heretofore or hereafter furnished, imposed by law and not shown on the public records. Probably this one here, more than any of them, is the biggest claim situation in title insurance is the mechanics liens. Because there's statutory periods in which when people do work on the property, they have a lien period that they can file a lien on the property. In the owner's affidavit, the owner will be asked if there's been any construction work done in the last 120 days. If that's the case, we may ask for sworn statements and waivers to make sure those lien rights are all covered. If not, if there is no work been done, and then in the owner's affidavit the owner swears to it, then we will remove that exception too.
The situation with liens has to do with the fact that when a lien claimant files his lien, it reaches back in time to the time that he began his work, not necessarily the time that the lien was recorded in the public records. So again, the standard exception is intended to deal with things that are not a matter of record, that we don't have the ability to check, that we can only eliminate based on the personal knowledge of the parties involved. Those are the standard exceptions, and hopefully we've given you a little insight on how we need, what sort of documentation we need to get rid of them.
I think the short answer is really you need an owner's affidavit and you need a survey, and that'll get rid of the standard exceptions.
Thanks for your time.